Jeanette Miller and Steve Berry, a motoring journalist, also with us. Is it the nature of the on-the-spot fine? Is that what's changing?
Absolutely, yes. At the moment, if you are prosecuted for careless driving, the matter has to go to court and a court will decide on the penalty, which could be between 3 and 9 penalty points, and the fine, which can be a lot more than the fixed penalty. The rules are to implement the ability for the police to actually issue on-the-spot penalties and fines.
Various constabularies across the country have launched a campaign today to target drink drivers in summer months. The main purpose of the campaign is really to highlight the fact that many people will get behind the wheel after attending summer parties or barbecues. I think because of a lack of awareness of alcohol consumption levels and how they affect the individual. I think most people are aware of campaigns going on around Christmas time, and people think that that is the time that the police are going to be more vigilant in checking drivers for alcohol consumption levels. So I think having a target to crack down on people in summer months is quite unusual.
John Englander, who has been allowed to carry on driving despite notching up a staggering 31 penalty points on his licence. Now, drivers are usually disqualified once they reach 12 points, but Mr Englander is still on the road with nearly 3 times the limit. So how did he do it?
Well, first of all, John, I'd just like to clarify, I think the reporting of this particular case is slightly misleading.
The festive season, a time, of course, when the message "don't drink and drive" is hammered home, but the government is now planning to tighten the law. Well, Jeanette Miller is from Geoffrey Miller Solicitors. Just explain in a little more detail what I alluded to there about how people have been able to get through a loophole.
I don't consider it to be a loophole. The statutory option is an option provided to any suspect at a police station who has provided a breath test which is 50 or below, the legal limit being 35 micrograms of alcohol in 100 millilitres of breath. So if you provide a breath sample at the police station which is considered borderline, so 50 or below, then the police must give an option to replace that breath test with either blood or urine. It's the police's decision which that will be. Right. Now, the loophole, as the government term it, is because when somebody says, yes, please, I'd like to replace the breath sample with, say, blood, in many cases, the government argues that there isn't a doctor or healthcare professional on the site of the police station. Right. By the time they get somebody there to take the blood sample, they argue that the suspect has been able to fall below the legal limit, and so they escape or avoid prosecution.
So it's a case of tightening the existing law?
Well, in my view, I don't think that this proposal should be implemented, but I think I'll probably be in the minority. At the moment, if you issued a fixed penalty for speeding, you're either speeding or you're not. Yes, you can argue against it, but it's a bit more black and white. You're on the phone, then you're either on the phone or you're not. You have no insurance, you either do or you don't. For careless driving, there's a subjective test involved. And the test for careless driving is that your driving fell below the standard of a competent driver. And the decision there as to whether somebody's driving has fallen below that standard is really up to the court.